California, Mr. Kiley, for 5 minutes.
Good morning. Mr. Baker, if I could start with you. I think you made a comment about how we need more of a leadership role for the United States when it comes to standard setting organizations. So I wanted to ask you just what are the ways that we could do that? There are examples of standard setting organizations that have managed to keep the Chinese influence at bay through appropriate governance measures. So maybe that's one route. Or maybe in other cases where China is gaining influence legitimately, how could we step up our involvement in these organizations, provide incentives for participation in them in order to match their influence?
That's an excellent question, because one of the things that happens with U.S. corporations that are not subsidized, when your budget goes down and your returns go down, you reduce your staffing at standards organizations. It doesn't occur with Chinese companies. When they're subsidized, they increase the number of individuals. As far as participation, remember, it's a technical standard. The idea of more engineers is a good thing. And I will disagree with one thing. The standard essentiality of something that's put into a standard is not addressed by a work group. I've been in the work groups, and that is specifically excluded. The technical elegance is what's included in the standard, and you sort out the septness later. The problem is nobody's sorting out that septness. It's a big question mark. So as far as participation, a great start would be having an initial threshold as far as the number of participants that could represent a company at a standard, changing voting rights so that the voting rights are reflected based upon an individual company gets one vote, and other such procedural methods. Some standards have implemented them, many others have not.
And so how could we sort of have more of a voice in setting those rules of governance?
That's a difficult question, because the whole idea of the standardization setup is to have it privatized under the Western philosophy. In China, it's slightly different. And Mark, you know more about that than I do. But as far as government being able to regulate it, I think there are certain programs where there is a role for government to play in trying to figure out the staffing levels for particular standards.
Sure. So let me revisit this question of sorting out the septness, as you put it, which refers to, I believe, whether the patent is truly standard essential. And you made a comment earlier about how true essentiality was a matter of whether the device needs to have that technology in order to work. But that seems maybe not quite technically the case. Isn't it a matter of whether you need to practice the patent in order to achieve compliance with the standard? In which case, having a standards essential patent is kind of like a tautology, because once it's in the standard, you have to use that technology to achieve interoperability. So which is it?
Yeah, Congressman, it's actually, you're describing it correctly, but the technical essentiality is part of the interoperability of the standard. If you take out that technical essentiality, it's not going to be interoperable.
Right. So there's the question of whether a technology is necessary for a device to work, and then there's a question of whether it's essential to achieve interoperability. But the latter question, is just a matter of the choice that was made in the standard setting process, right? Different choices could have been made to use different technologies to achieve the same level of interoperability. So is it your argument that essentially renders it not a set patent, or does that go to the setting of FRAND rates because there exist viable alternatives, not to practicing that particular standard, but rather to achieving some level of technical interoperability?
You're actually hitting on a very good point, because there are different parts of a standard. There can be the main part of the standard, and there can also be appendices to the standard. So if you're talking about what is the most technically elegant way to achieve something, given all of the engineering parameters around what that standard seeks to achieve, that would be what's technically essential. That doesn't mean a different way of doing it in a different part of the standard would not yield standard essential patents if you implement that part of the standard.
All right, interesting. Yeah, it seems like an area worth exploring. I guess that part of the issue is that it's just such a mess in terms of what the standard is. Well, probably a bad word to use standard again, but what the framework is for setting FRAND rates, that it's created all of this confusion and uncertainty. But Dr. Copen, I wanted to also give you an opportunity here, because I was glad you mentioned the PARA, which I've introduced, a piece of bipartisan legislation, bicameral, which would go a long way towards clarifying subject matter eligibility, creating more certainty for those who are looking to innovate. Could you talk a little bit more about how that is particularly relevant to the general theme of today's hearing, which is the ways in which China has come to use dominance of intellectual property as a major tool against the United States.
Thank you so much, Congressman Kiley, and grateful for your leadership in PARA. The opportunity to provide greater clarity on patentable subject matter is absolutely important in the United States with respect to the enforceability of IP rights, as well as to understand how they read upon the practice of a standard. And that clarity benefits not only the United States practitioners, but companies from other nations as well, seeking to access the United States market.
Thank you. I yield back.
Thank you.